Welcome to Crime in Court. This is episode number 105 of the Canton cover up series, Commonwealth versus Karen Reed, and we are talking about Hank Breenan and more of his baseless motions that he has filed. So that is what we're going to go over today. He has put a he has filed a bunch of motions in the last, however many weeks as I've been recovering from the flu, and I'm getting back to catching up with these. So, we have quite a few different motions to go through. They're not very long, so let's get to it. All right, so we've got the Commonwealth's motion to amend the December 5th, 2024 order pertaining to audio recordings in possession of Gretchen Voss and or Metro Corp. So Gretchen Voss, what is she, Boston Magazine or something like that? Sh They've been trying to get her notes for forever. So the Commonwealth moves to amend this court's December 5th order restricting the dissemination of all audio recordings produced by Gretchen Voss and or Metro Corp. 1. Commonwealth respectfully requests to expand the court's order restricting dissemination to counsel and the defendant only. Prior to seeking leave of court, the Commonwealth inadvertently forwarded the material to a stenographer for transcription. The Commonwealth requested that the stenographer, what does inadvertently mean? Commonwealth requested that the stenographer not listen to the audio, and to date, only undersigned counsel has listened to the audio recordings. In addition to counsel, the Commonwealth respectfully requests that the court amend its order to allow the audio recordings be shared with a paralegal, a multimedia assistant, and a stenographer to prepare the defendant's statements for presentation at trial. The Commonwealth asserts that this modification is necessary and appropriate to permit the Commonwealth to effectively prepare for the April 1st, 2025 trial, which I have to break it to you, it's probably not going to happen now that we've got the federal. It's not even an appeal, it is a new brief for Karen Reed regarding charges 1 and 3, her double jeopardy rights. So we are probably not going to go to trial very soon with that happening. All right, so um, it appears they're trying to get the stenographer and these other people to print out this audio recording from Gretchen Voss because they're going to use it at trial for whatever reason. So, all right, here is now Hank Brennan's motion to exclude ARCA. None of the things that he talked about in this week's hearing are in here. So anything that he talked about regarding Alan Jackson talking to ARCA or any payments that might have been made, that is not in here. So their reason to strike the ARCA witnesses is not based on anything that happened at the hearing this week. So let's get into it. The Commonwealth moves to exclude the defendant from calling employees of ARCA, including but not limited to Daniel Wolf, PhD, and Andrew Rentschler, PhD, due to the defendant's failure and inability to comply with discovery obligations under Mass R. Crim P 14. As revealed during the defendant's first trial, Dr. Wolf and Dr. Rentschler were two experts retained by the federal government in furtherance of the U.S. Attorney's investigation of an unspecified federal crime. Both Dr. Wolf and Dr. Rentschler admittedly did not review all pertinent and relevant evidence that exists in this case. You don't need to. Asserted that they did not speak with the defense prior to their testimonies and conducted experimentation and analysis that exceeded the facts and evidence in this case. Nonetheless, the court permitted both Dr. Wolf and Dr. Rentschler to testify on behalf of the defendant in June 2024. The parameters of the experts' opinions were not provided by the defendant prior to her first trial, and portions of the experts' opinions were not expected nor properly noticed. Uh, okay, so the feds turned over 3,000 pages of evidence to both sides. The prosecution had an opportunity. They had everything that the defense had about Dr. Wolf and Dr. Rentschler and their opinions, and they had every opportunity to call them themselves, and they didn't. So what does that tell you? They had the reports from ARCA stating that this accident, car accident, never happened. So for them to just continue going forward with the prosecution is ridiculous. But here we are. They have doubled down more than 2 times. It's bajillion down, I don't know. Furthermore, during the first trial, Dr. Wolf and Dr. Rentschler testified to reviewing information that was not known prior to rendering their opinions, and this was not previously disclosed to the Commonwealth. Prior to and during the defendant's first trial, the Commonwealth repeatedly moved for reciprocal discovery from the defendant. Citing a restraint and inability to comply with the Rule 14, the defendant failed to provide the Commonwealth with any discovery from ARCA, Dr. Wolf, or Dr. Rentschler. They were under strict orders not to get certain things. I mean, they were only allowed what they were allowed. Both sides got it. That doesn't mean that you shouldn't allow that they could be called as witnesses. That makes no sense that you would restrict them from being called as witnesses because the AG's office didn't turn over every single little thing that the prosecution is asking for. To allow the defendant ample time to retain her own experts and to prevent any delays in the April 1st trial date, on December 5th, the Commonwealth renewed its request for discovery, enumerating 13 areas of discoverable materials related to ARCA from the defendant. On July 6th, on January 6th, the Commonwealth notified the court and the defendant of its intention to move to exclude ARCA and Dr. Wolf and Dr. Rentschler based on the defendant's repeated failure and inability to comply with Rule 14. To date, the defendant has filed no response nor produced any additional discovery. On February 6th, Attorney Jackson indicated to the Commonwealth and this court that he intends to call experts from ARCA, presumably Dr. Wolf and Dr. Rentschler, as at the defendant's upcoming trial. On December 4th, the Commonwealth filed a written request for discoverable material from the U.S. Attorney's Office pursuant to 28 CFR, whatever, 2E request, in Exhibit A. The Commonwealth moves pursuant to Trial Court Rule 8, Uniform Rules of Impoundment. Okay, so they want to impound exhibits with the court. On January 30th, 2025, the Commonwealth and defense received a response from the U.S. Attorney's Office citing certain federal statutes and regulations that restrict the complete discovery the Commonwealth is entitled to. Peculiarly, despite the formal 4-page letter received on January 30th, 2025, following the parties' appearance before this court on February 6th, the Commonwealth and defense received an email from the U.S. Attorney's Office stating that their contract with ARCA ended on July 31st, 2024, and should either party wish to engage ARCA for additional analysis, any further engagements must not infringe on any federal privileges. So, Rule 14 demands reciprocal and expert discovery. As the proponent of the evidence, the defendant bears the full obligations of Rule 14. This rule provides for an automatic exchange of discovery regarding intended expert opinion evidence. The defendant cannot shield herself from discovery obligations. Isn't that rich? They're not turning over a whole bunch of stuff, including still Sally Port video that is still being discovered. And they're not giving the metadata or allowing for them to receive the metadata in any way. Yet The defense is the one skirting their defense obligation or their discovery obligations. Sure, sure, Hank. The defendant cannot shield herself from discovery obligations by citing restraints by the U.S. Attorney's Office or by now perhaps claiming to have independently retained ARCA for additional analysis and producing only a limited portion of expert discovery. Commonwealth remains unduly prejudiced by the defendant's delays in providing appropriate discovery and notice to the Commonwealth. The Commonwealth has diligently sought expert discovery from the defendant and U.S. Attorney's Office for approximately 10 months. A second voir dire is not an appropriate remedy as the defendant has continued to sidestep their discovery obligations. The Commonwealth is entitled to a fair trial, says who? They have all the power and the guns behind them. But apparently they're entitled to a fair trial and simply has sought what every criminal defendant in the Commonwealth of Massachusetts is obligated to produce. The Commonwealth is entitled not to repeatedly be ambushed at trial and be permitted to effectively prepare for cross-examination of any witness. Here's the thing, though, Hank. You have all the discovery. You're not going to be ambushed. You pretty much know what they're going to be testifying to. You can go back and watch their testimony from trial 1 if you're still unsure. So this isn't a trial by ambush. Alan Jackson didn't know what they were going to say either when he called them the first time. He wasn't quite sure, but he took the chance, knowing that he had this report from ARCA saying that it didn't happen. So he took the chance and called them anyways. And you know what? It worked out really well for them, except for the fact that the jury didn't know that they were hired by the FBI, so they thought Turtle Boy hired him, which makes no sense. But anyways, so they didn't give them the appropriate weight that they should have been given. Commonwealth is entitled not to repeatedly being ambushed and be permitted to effectively prepare for cross-examination of any witness. Strategic decisions do not alleviate a defendant from discovery compliance, and after 10 months, the only appropriate remedy is exclusion. A criminal defendant constitutional right to call a witness on her behalf is not absolute and may be limited in the judge's discretion in the face of legitimate demands of the adversarial system. And that is from Hanky Spanky. And he also has, this was his exhibit A, I guess, motion to impound. The Commonwealth moves pursuant to Trial Court Rule 8, Uniform Rules of Impoundment Procedure that exhibits A and B to the Commonwealth's motion be filed under seal and impounded. So there's 2 exhibits that we didn't get to see. These letters contain the Commonwealth's written request for discoverable material from the U.S. Attorney's Office and the U.S. Attorney's response pursuant to this 28 CFR 2E request in consideration of the protective endorsement of the protective endorsed by the Honorable Denise Casper of the United States District Court of Massachusetts. These letters could be considered confidential and not subject to public disclosure. Okay, fine. Now, here is Karen Reed's response to that motion. We are going to read through it in just one second. Now comes the defendant, Karen Reed, and respectfully requests that this honorable court deny. I mean, I think that's being generous calling her honorable, but what do I know? I don't think Bev is honorable. One second. Sorry, I had a cough. All right. Excuse me. So they are saying or respectfully requesting that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA, namely Daniel Wolf and Andrew Rentschler. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Desperate and transparent. That is how you can describe Hank Brennan. The Commonwealth cites no legal authority whatsoever to support its extreme request to exclude these exculpatory witnesses. The Commonwealth falsely suggests that the defense has failed to comply with reciprocal discovery obligations under Mass Art Crim P14, but its motion is improper, unsubstantiated, and contradictory to binding legal rules and precedent in Massachusetts, and if granted, so if she were to grant Commonwealth's motion, would constitute an egregious violation of Ms. Reed's state and federal constitutional right to present a defense. Commonwealth alleges that the defense has failed or is unable to comply with its reciprocal discovery obligations, and that it requested and has sought discovery from the defense and U.S. Attorney's Office pertaining to ARCA witnesses for about 10 months. But as the Rule 14 states, a defendant's reciprocal discovery obligations do not begin until after the Commonwealth's delivery of all discovery required pursuant to subdivision A1A or court order. So the defense, they are not required to provide reciprocal discovery until and only after the Commonwealth completes all of their discovery obligations. So it's a little preemptive to be saying, well, we haven't received all of their discoveries because it's not due yet. So, but we haven't received it, so you should just exclude them. Notably, the Commonwealth did not file its certificate of compliance until the last hearing on February 6th of this year. However, the certificate of compliance is meaningless because the Commonwealth has conceded that it still has additional mandatory discovery required under Rule 14, and it is not turned over to the defense. Among other things, the Commonwealth has failed to disclose the identity of an additional expert who worked on the reconstruction, has not turned over certain underlying data associated with its expert's reconstruction analyses, has not turned over metadata associated with the Canton PD surveillance videos, and continues to withhold additional communications between and among law enforcement officers and witnesses in this case. I wonder where those Michael Morrissey emails are at, too. Remember, he was caught on a burner email account talking to witnesses in the Turtle Boy case, who also happen to be, witnesses in this case. So, interesting, huh? The Commonwealth, thus, is well aware that the defense's discovery obligations have not been triggered because the Commonwealth itself has not complied with its own discovery obligations. So, you want to uh, talk, Hank? You want to say we're not doing what we're supposed to be doing? Actually, no. Let's walk it back a few seconds here and let's be honest about what's happening. Ironically, Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. So, how is she able to turn that over? Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. So, from their last hearing, um, so not this past hearing, but the hearing before that, the defense says that they've turned over discovery. So that new discovery that Hank was talking about in the hearing, that's probably what this is. The discovery that they are turning over for trial number 2, which isn't even due yet, but they were doing it because they wanted to be in compliance and not piss Hank off. But it seems like nothing the defense does is right. Like, no matter what option or choice they have, no matter what they do, it seems to be wrong in the eyes of the Commonwealth. It's ridiculous. The notion that the Commonwealth lacks sufficient information regarding the testimony of the ARCA experts in order to adequately prepare for trial is ridiculous. I agree. The Commonwealth, I'm laughing because I just said that word. Like, this whole thing is ridiculous. Commonwealth has already had 2 opportunities to cross-examine the ARCA experts, first at a voir dire hearing before the first trial, and again at the first trial in this matter. The Commonwealth seeks to deny Ms. Reed her most basic and fundamental constitutional right, the right to present a defense as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 6th and 14th Amendments of the United States Constitution, not because of any discovery violation, but because this evidence is manifestly exculpatory and undermines the Commonwealth's entire case. Damn. Commonwealth's motion is baseless and violates Ms. Reed's most basic and fundamental constitutional rights, the right to a fair trial and a right to present a defense. The Commonwealth cites no legal authority to support its extreme request to exclude 2 of the most exculpatory defense witnesses in this case, Dr. Wolf and Dr. Rentschler. Dr. Wolf and Dr. Rentschler were hired by the United States Attorney's Office to conduct an independent review, analysis, and testing surrounding the singular question of whether John O'Keefe died as a result of an auto-pedestrian collision with Ms. Reed's SUV. These highly qualified experts have determined to a reasonable degree of scientific certainty that 1. John O'Keefe's injuries do not result from being struck by Ms. Reed's SUV, and 2. The damage to Ms. Reed's SUV did not result from colliding with John O'Keefe. In other words, the scientific data establishes that Ms. Reed did not strike John O'Keefe with her vehicle. The Commonwealth cites only 2 cases in its motion to exclude these exculpatory expert witnesses. These cases not only fail to support the Commonwealth's request, but actually directly contravene the Commonwealth's argument. Commonwealth's failure to properly inform the court of adverse precedent in the very cases the Commonwealth cites borders on unethical. So this Commonwealth apparently cited these cases, but they weren't exactly it didn't end up the way that they're being represented by the Commonwealth, it seems. First, the Commonwealth cites Commonwealth versus Pava for the proposition that Rule 14 provides for the automatic exchange of discovery regarding intended expert opinion evidence, and that the defendant cannot shield herself from discovery obligations by citing restraints by the U.S. Attorney's Office. Nothing in Commonwealth Pava suggests that a defendant has an affirmative obligation to obtain discovery that is not in her care, custody, or control. Moreover, notably missing from the Commonwealth's recitation of Pava is the court's holding that short of a finding of bad faith, the extreme sanction of excluding an exculpatory expert witness is never the proper remedy. In Pava, the defendant hired a firearms expert several weeks prior to trial who, if permitted to testify, would have opined that the alleged firearm used in the crime could not have been fired in the manner claimed by the Commonwealth's expert witness. The defendant failed to comply with any of the mandatory discovery obligations under Rule 14. The defendant failed to provide notice of the expert witness, failed to list the expert in the pretrial conference report, and failed to provide any discovery related to that expert opinion. So all the things It's not comparable. So this case, it just isn't comparable to Karen Reed because of all those reasons. In the middle of trial, after the Commonwealth rested, the defendant sought to call the expert witness and the Commonwealth objected. The lower court excluded the expert witness on the basis that there was no attempt to comply with Rule 14, to notice and no notice given and no information provided to the Commonwealth as to the defendant's intent to call the expert witness. So there were violations on the defendant's part here. This is not the case in Karen Reed. She has turned over everything that she has in her possession. But further than that, she can't do anything else. She can't force the AG's office to turn this stuff over, and it's not her responsibility to. So even in spite of these egregious mandatory discovery violations, the appeals court of Massachusetts reversed the lower court's decision and held that the trial court's exclusion of this expert was prejudicial error. So what Hank just put in his motion, he it's not comparable, and the result ended up being reversed. So real bad um, example there from Brennan. And that some lesser sanction should be employed. In doing so, the court explained the materiality of the proffered evidence was such that the defendant's constitutional right to call witnesses to defend himself is implicated. We recognize the legitimate demands of the adversarial system. Those demands, however, are in place to serve the system's objective of fair resolution of disputes on the merits. The preclusive sanction should be reserved for hardcore transgressions. You don't want to just willy-nilly exclude people's defense and prevent them from being able to defend themselves. In the absence of a finding of bad faith on the part of the defendant, and given both the materiality of the evidence and the relative ease with which any prejudicial sorry, let me read that over again because I can't read. In the absence of a finding of bad faith on the part of the defendant, and given both the materiality of the evidence and the relative ease with which any prejudice to the Commonwealth could have been avoided, we conclude that this is a case in which enforcement of the procedural rules should have been secondary consideration. Second, the Commonwealth cites Commonwealth versus Dranka for the general proposition that Ms. Reed's constitutional rights to present witnesses can be limited. The Supreme Judicial Court has laid out 5 factors which must be taken into account in assessing this balance: prevention of surprise, evidence of bad faith in the violation of the conference report, prejudice to the other party caused by the testimony, the effectiveness of less severe sanctions, and 5, the materiality of the testimony to the outcome of the case. Yet again, the facts and law set forth in Drunka make clear that the Commonwealth's request for exclusion must be denied. In fact, the Drunka court explicitly states that even where the Commonwealth would be prejudiced by discovery violations under Rule 14, the preclusive sanction should be reserved for hardcore transgressions. And as noted in the reporter's note to Rule 14c2, a court should only employ an exclusionary sanction when convinced that a failure to comply with an order was deliberate and prejudicial to the Commonwealth. I think this is what Hank is going for. He's trying to say, oh, well, they violated their whatever, AJ violated his um the court's orders or whatever because he spoke to them. He communicated with them in order to coordinate, getting them there for testimony. If she wants to see that as some like blatant um and deliberate hardcore transgression, which it's not. and it shouldn't be, but if she wants to do that, that's what I think Hank is going for, trying to make it seem like, well, the feds turned this over, not the defense. But then he corrected himself, so we shall see. In Drenka, the appeals court held that the lower court erred in excluding a witness on the basis that the defendant failed to provide notice of witness in the pretrial conference report and instead disclosed the identity and subject matter of the witness on the first day of trial. In doing so, the court explained that the defense's late disclosure of a witness when the Commonwealth was only notified about the evidence day 2.5 days prior to the testimony still gave the prosecution ample time to prepare for the examination. So, being sprung upon them, ambushed, let's say, by this particular defendant, not Karen Reed, this example. This person sprang it on them on the first day of trial, saying, "Yeah, you're going to get testimony from this person," and they still decided that that's plenty of time to prepare for your cross examination. As they say, ample time to prepare for examination of this witness with or without a short continuance, and that the preclusive sanction is not warranted. Here, the test for exclusion is objectively not met. There is no evidence of bad faith. The defendant has complied with all of her discovery obligations relating to the ARCA experts. The Commonwealth, even in its notice of the Commonwealth's intention to exclude ARCA witness, filed on January 6th, concedes that the Commonwealth does not allege that the defense will be negligent or unwilling to comply. Rather, it is expected that given the handling and employment of these witnesses, the defense will simply be unable to meet its obligations. As this and other courts have long held, cases should be tried on the merits. Moreover, the notion that the Commonwealth lacks sufficient notice regarding the testimony of the ARCA experts in order to adequately prepare for trial is ridiculous. There's that word again. It is ridiculous. But it's true, and I brought that up too. They already know what the ARCA witnesses are going to be testifying to, so this isn't springing on that. This isn't an ambush. You're not being sprung up. It's not being sprung upon you at the last minute where you have no idea. You can even watch their testimony from trial one if you are unsure. So the Commonwealth has already had two opportunities to cross-examine the ARCA experts, first at a voir dire hearing before the trial and again at the first trial in this matter. There is no element of surprise. The Commonwealth has been on notice that the defendant intends to call the ARCA experts for almost a full year at this point. The defense has already turned over to the Commonwealth all the materials pertaining to ARCA in the care, custody, and control of the defendant as required by Rule 14 and as ordered in response to the Commonwealth's December 5th motion for reciprocal discovery pertaining to employees of ARCA. Furthermore, the Commonwealth has access to the ARCA's experts' reports, the materials that they relied upon in reaching their analysis, the experts' CVs, the transcripts of their respective experts' testimony at the voir dire hearing and the first trial in this matter. There is no good faith basis to suggest that the Commonwealth will or even could be ambushed at trial during the testimony of the ARCA employees. I mean, great point. Moreover, at the Commonwealth, as the Commonwealth has conceded, there is no evidence of bad faith. The defense has turned over all the required materials in their possession regarding these witnesses, and the Commonwealth itself has noted that it does not believe that any nefarious action has occurred on the part of the defense. To the extent that the Commonwealth believes there is outstanding discovery, such documents simply do not exist. Again, the Commonwealth in the present case has long had access to ARCA discovery through reports and prior testimony. It is startling and baseless for the Commonwealth to argue that Ms. Reed's constitutional right to present exculpatory witness should be limited due to the Commonwealth's perceived inability to conduct a cross-examination of Dr. Wolf and Dr. Rentschler. The Sixth and 14th Amendments of the U.S. Constitution, as well as Article 12 of the Massachusetts Declaration of Rights, demand that Ms. Reed is entitled to present witnesses on her own behalf and to compel their presences. Commonwealth seeks to violate Ms. Reed's most basic constitutional right to present a defense and exclude the testimony of exculpatory defense experts on contrived procedural grounds. This case must be decided on the merits by a jury. None of the factors supporting exclusion of exculpatory expert testimony, as governed by Rule 14, have been met. Accordingly, Commonwealth's motion for to exclude employees of ARCA must be denied. In the titling of their motion, for to exclude, as you see in their title. So that was just an error on their part. The motion to exclude ARCA employees must be denied. Wow. Just, geez. I mean, I don't even know what to say with everything and the way that Hank has been playing not so fairly. And before before Hank's little lies in court on Tuesday, I um I didn't think that Judge Bev would exclude ARCA, but now I'm thinking that's what possibly they're trying to exclude ARCA and get Alan Jackson removed, his pro hoc vice removed. Um, I don't think it's going to come down to that, especially now that he corrected himself and Bev may have some time to cool off her head, but who knows? So we shall see what happens with that. All right, here is the next motion. The Commonwealth's motion response to the defendant's motion to compel discovery. So we went over that in a previous video, the motion to compel discovery, and this is their response. So now comes the Commonwealth in response to the defendant's February 11th request for material pursuant to Rule 14. The Commonwealth addresses each request as follows. Number one, all chain and custody logs, reports, evidence logs, and or other documentation regarding how the DA's office and or the state police came into the possession of each distinct production of video surveillance footage from CPD, Canton Police, that has been provided to the defense. The Commonwealth agrees to the extent such items and information exist and are within the control and custody of the Commonwealth is not obligated under Rule 14 to create any timelines or work product logs that do not exist. No one's asking for that, but the stuff should already exist, is the problem. An unredacted copy of MSP Report Number 26 related to the death investigation of Sandra Birchmore. The Commonwealth objects as beyond the scope of Rule 14. The defense has made absolutely no showing that the request is material and relevant to the case. In Tuesday's hearing, Liza Little, went over this. She argued this motion for the defense, and she was brilliant. And she talked about how the same exact people in the Sandra Birchmore investigation are the same exact people implicated for their misconduct, potential cover up of John's death in the Karen Reed case. So it's all related. It's definitely related and relevant. An unredacted copy of the public records response relating to all email correspondence and communications associated with the Sandra Birchmore investigation. The Commonwealth objects as beyond the scope of Rule 14. The defense has made absolutely no showing that the request is material and relevant. BS. Unredacted copy of all reports, communications, handwritten law enforcement notes, and or other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in this case. Commonwealth objects again as to the scope of Rule 14. The defense has made no showing that it's material and relevant. I totally disagree. All communications, documents, reports, memorandum, recordings of interviews, physical evidence, findings, and or other evidence relating to internal affairs investigation into Trooper Michael Proctor, including transcripts of administrative proceedings. The Norfolk DA's office has provided all material regarding Trooper Proctor's internal affairs investigation that is presently within its custody and control. The Supreme Court has deemed internal affairs divisions to be outside the scope of the prosecution team and therefore rejected any suggestion that internal affairs records, even if relevant material, must be produced by the prosecution. Police Department internal affairs records are not subject to automatic discovery and fall outside prosecutors' possession. All material and relevant communications made between members of law enforcement and witnesses in this case, including but not limited to Sergeant Yuri Buchanan and Chris Albert, by email, address, and or cell phone from the inception of this case to the present. If you recall, in their motion, Yuri and Chris were emailing or texting, somehow communicating back and forth regarding, and this was after trial, regarding people with Free Karen Reed t-shirts and things like that, and rubber duckies and whatnots. So all the little things that terrify Chris Albert because he's such a wuss that he can't even look at a Free Karen Reed t-shirt without having his feelings hurt. Then he calls up Yuri and tries to get people arrested. So there's that. They're looking for that. They do not object. That's interesting. So there is no objection to those communications between Yuri and Chris. The Commonwealth will continue to provide statements of witnesses and all material the defendant is entitled to under Rule 14. All copies of all notes and correspondence regarding any testing conducted in this case, along with all research and materials relied upon by the Commonwealth's expert in completing their analysis, regardless of whether the witness will be testifying to the information at trial. They say, no objection, the Commonwealth has already produced. The Commonwealth recognizes its ongoing discovery obligations should any additional material be produced. So it's saying they've already produced this, but obviously not if they're asking for additional materials. All communications between members of the Norfolk DA's office and or its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case include dates and substance of phone calls, copies of any written correspondence, dates of any strategy meetings, and a list of materials received. They say this request is overly broad. The Commonwealth objects as beyond the scope of Rule 14. The Commonwealth will continue to provide statements of witnesses, expert reports, and all material the defendant is entitled to. All written communications, including emails and text messages between any member of the Norfolk DA's office and or its law enforcement agents and any expert the Commonwealth intends to call at trial. So those Michael Morrissey emails, where are they? What did they say? I'm so curious. The request is overly broad. The Commonwealth objects as beyond the scope. The Commonwealth will continue to provide statements of witnesses, blah, blah, blah. So they really haven't answered anything. They're saying the defendant is not entitled to work product, including its legal research, opinions, theories, and mental impressions from the Commonwealth. So there's that. Legible copy of the NDAO report, whatever this is, and the Commonwealth says they will produce that. And that is signed by Meatball Morrissey and Hank Brennan. All right, next we have three more motions to get through, but two more motions and an affidavit, I should say, but it's not that long. So here is the Commonwealth's response to the defendant's motion to compel discovery for a forensically sound copy of the January 29th video surveillance footage in law enforcement custody. So, obviously, the defense wants the metadata. They want the the forensically sound copy of the footage. They want the way that the data should have been preserved and handled. That's how it should be turned over. But let's see. The Commonwealth says, now comes the Commonwealth in response to the defendant's motion to impose condition relative to its production of surveillance footage. Background. After informing the defense that copies of some footage exists on a data file at the Canton Police Department in the detective file, the Commonwealth's multiple attempts to provide the footage to the defense have become unnecessarily bogged down by needless attempts to complicate the process. Seriously? They were trying to deal with this without having to do motions, and Hank was like, put it in a motion. I don't want to deal with all your requests or working with you, so put it in a motion. Despite vacillating and frustrating the production of the discovery, the defense actually cites their delay of this production as one of the basis for its opposition to reciprocal discovery. Whatever footage exists can and should be produced consistent with the standard practice of reproducing stored video. The Commonwealth simply needs to click and drag copies of any stored videos to a hard drive and produce the material to the defense. The Commonwealth previously provided the defense an opportunity to attend and participate in this very basic and uneventful procedure. After the defense deferred on taking a position, the court at the February 6th hearing directed the parties to meet and attempt to reach an agreement. Immediately following the court hearing on February 6th, four attorneys from the Commonwealth, along with Attorney Jackson and Attorney Yannetti, remained in the courtroom and met to reach an agreement. The parties agreed that the Commonwealth would have a person copy the video files from the detective file and store the videos on a hard drive and then produce a copy to the defense. The Commonwealth also suggested and agreed that it would videotape the procedure. The Commonwealth memorialized the parties' agreement in writing and sent it to the defense. Although she had not been in court on February 6th and did not participate in the parties' meeting and agreement, Attorney Little began lodging emails attempting to alter and change the agreement that was already made between the parties. In a progressive series of self-serving emails, What? In a progressive series of self-serving emails, Attorney Little filed the instant motion, including her own emails. Aside from its complaint, the defense provides little detail and claimed entitlement for forensically sound copy, metadata, and logs. Not only are these demands outside the agreement of the parties, the request ignores the facts that the database is not an NVR DVR. The unit is a separate hard unit or hard drive that files were simply clicked and dragged into by the detective who produced video in this case. The video stored on the detective file has not been inventoried or reviewed by a prosecutor to date. The Commonwealth intends on meeting its obligations by making a copy of any such video and providing it to the defense. Well, they're still getting it in piecemeal, so I don't know what they're doing, but they're doing it wrong. And by sitting here and trying to say Liza Little is self-serving when she is trying to make sure that the process is probably done in a way that makes sense and is appropriate, and she's trying to coordinate across everybody, I'm sure. She's not trying to like change everything. I'm sure she was trying to be a part of the conversation because there might have been things that needed to be addressed still. So that's all I'm saying. He shouldn't be disparaging another attorney in his filing. and then saying that um, the defense is demanding forensically sound copies and metadata and logs. Those are things that should have been turned over regardless. It's not a demand. These are things that you're required to do, Hank. You're required to hand these things over. And here is an affidavit in support of the Commonwealth's response to the defendant's motion to compel production of a forensically sound copy of the January 29th video surveillance footage in law enforcement custody. So, at a hearing in the case on February 6th, the court directed the parties to meet and attempt to reach an agreement about the production of unspecified surveillance videos that may be stored on a hard drive at the Canton PD. After the hearing, Special Assistant District Attorney Hank Brennan, ADA Laura McLaughlin, ADA Adam Lawley, ADA Caleb Schillinger, and a paralegal for the Commonwealth met with Attorney Jackson and Attorney Yannetti in a small room at the back of courtroom 25. Attorney Little was not at court all day and did not participate in the parties' meeting. All parties agreed at that time that the Commonwealth would have a member of the prosecution team copy any surveillance video footage in the detective file, store the materials on a hard drive, and then produce a copy to the defense. The parties further agreed that the Commonwealth would videotape the process and provide a copy of the videotape to the defense. Moreover, the defense specifically declined to attend and participate in the process. And that signed under penalties and perjury. I don't know what Hank is on about there. So that's what he's got to say about that. I'm not really sure what the big deal about this is, but they want the metadata. It's not that difficult. I don't know why it's so hard to get the metadata from the Commonwealth, especially for that Canton Police Department video. And finally, you might have heard about this, they are trying to impose sanctions on the defense. So here is the Commonwealth's motion to impose sanctions pursuant to Massar Crim P Rule 48. Now comes the Commonwealth and requests that this honorable court impose sanctions against the defense for their repeated and willful violations of court rules and protective orders. Well, if that's not a bunch of BS, I don't know what is. What about all of the Commonwealth's willful violations? That's coming. This is probably in response to the fact that he knows that there's going to be an egregious government misconduct um, filing coming out in the near future. So this is probably his response to that, or his attempt to circumvent it. I don't know. So, under Massar Crim P 48, willful violations by counsel and violations of court orders shall subject counsel to such sanctions as the court shall deem appropriate, including citation for contempt or the imposition of cost or a fine. The purpose of this rule is to regulate the conduct of attorneys who practice therein the courts of the Commonwealth and to discipline those whose actions fall short of accepted standards. On February 11th, 2025, in the defendant's motion to reconsider reciprocal discovery order, it appears that the defense flagrantly violated protective orders previously agreed to by the defendant and set by this court on November 13th, 2024 and January 31st, 2025. In the defendant's motion, it quotes a text message sent by Trooper Michael Proctor. This text message is subject to the protective orders, and the January 31st, 2025 order specifically restricts the public dissemination of all communications, including 1. Those within the work cell phone of Massachusetts State Trooper Michael Proctor. The defendant attempts to unilaterally amend the protective orders by claiming that only the screenshot of Proctor's text message is subject to a protective order. This is an obvious violation of the protective orders. Further, the defense claim that the protective orders are limited to personal identifying information is misplaced. Before communications were produced to the defendant, personal identifying information such as phone numbers were redacted. The purpose and necessity of the protective orders, as stated, is to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. A reoccurring issue and concern in this case. Notably, this is not the defense's first violation of a protective order of or court rule. The defense has repeatedly displayed autopsy photographs of the victim without permission of the court and has previously filed motions with photographs and names of juvenile witnesses, photographs of the victim's deceased body, and has released witnesses' identifying information to include their name, date of birth, social security information, addresses, and phone numbers. They're public documents. That has nothing to do with the defense. How do you know that the defense is the one that's releasing them? You don't. Further, this court previously ruled that it is unacceptable for defense counsel to misrepresent and distort facts in impounded documents and to fail to comply with orders of this court, all of which have happened in this case. The court will not tolerate actions by defense which waste the court's time and resources or violate the rules. Therefore, the Commonwealth moves that the defense be sanctioned to include, but not limited to, being ordered to file all motions under seal and impounded until such time that both the Commonwealth and court can ensure that the filings comply with all previous orders set by the court. This is ridiculous, if that word hasn't been used enough. The content of improperly filed motions serves to taint the prospective jury pool. So you're mad because Michael Proctor looks bad. You're protecting Michael Proctor by putting this motion out there. You care more about Michael Proctor's integrity than a fair trial for the defense. Got it. And that's the end of that. So that's all I have for this episode regarding motions, anyways. So we had a lot of motions, a lot of different topics to get through. What do you think? I would love to know your opinion. Please hit that like button and let me know what you think of the Karen Reed case and what's going on and how all these motions and things are affecting the case. Let me know what you think. I look forward to hearing what you guys have to say in the comments below. Thank you guys for watching. Take care. Bye now.